All right, welcome back everyone for the second panel of our workshop or conference today. We are starting a little bit later than scheduled, but I'm told that this is on account of a wonderful lunch. So at least there's that. We are joined here for the second panel by Dr. Markus Gehring, who is joining us online, Dr. Efthymios Papastavridis to my immediate left, and Dr. Mihail Vatsov down the table. My name is Nina Mileva. I'm a PhD researcher with the TRICI-Law project, and I'm also a lecturer here at the University of Groningen. For this panel, we'll follow roughly the same format as for the first panel. So our speakers will have 15 minutes for their presentations, and after that, we will do the questions. In the interest of time, I will immediately start with our first presentation so that we have the most time possible to both hear our speakers and to have a nice discussion. We will be beginning with a presentation by Dr. Markus Gehring. Dr. Gehring is a visiting professor of law at the Yale Law School and was director of the Center for European Legal Studies at the University of Cambridge. Dr. Gehring also serves as a tenured associate professor of law in Cambridge Faculty of Law and as a fellow in law at Hughes Hall. He's a founding fellow of the Cambridge Center for Environment, Energy and Natural Resources and also a fellow at the Lauterbach Center. Dr. Gehring, the floor is yours.
Thank you so much. And I would like to thank you to the organizers and apologies again for not being there in person. I only just returned to Cambridge and I'm speaking to you from the Lauterbach Center. I have some slides that I'd like to share. So if I can share my screen, that would be great. I'm not sure whether that works, but I've put together, I've put together a couple of slides. Can you, now I can't see you, but can you see my screen?
Yes, we can see your slides. Is there any chance, Dr. Gehring, to increase the volume on your side? Because we can hear you a bit weakly.
Okay. Is this better in any way?
Yes, thank you very much.
Yeah. Yeah, so I've put together some slides and I apologize, the final paper is still in the making, but I wanted to tell a bit of a story where I think the European Union has directly influenced and triggered a new interpretation of an established customary norm. This norm is the obligation to conduct an environmental impact assessment, and I will first briefly introduce this customary norm. I'm not sure how familiar the audience is with that norm, but it's a new customary obligation, and it has already received a new interpretation, and that's largely due to the practice of the European Union to conduct sustainability impact assessment, so as opposed to environmental impact assessment. I will sort of report on some of the international practices of environmental impact assessments, and then propose that the new interpretation of this customary norm has taken hold and offer some preliminary conclusions. Impact assessment, the audience will be familiar with it. It's the oldest and procedural environmental right. It was developed in the 1970 National Environment Protection Act in the United States, where it's known as EIA. It was introduced in the European Union legal context in 1985 and has been reissued several times, most recently in the Directive 2014-52 that became, that member states had to transpose by 2017. It's also introduced for programs and plans and applicable for internal commission decisions as sustainability impact assessment according to 2005 and 2016 guidelines. Environmental impact assessments were already recommended in Principle 17 of the Rio Declaration as a national instrument. And so there is a bit of a development with regards to this rule of customary international law, because it starts as a national instrument and then is applied in transnational international context. In 2001, the International Law Commission drafted articles on the prevention of transboundary harm, and Article 7 asks for a risk assessment, meaning an environmental impact assessment. In the ESPO Convention and its Kiev Protocol, we then have specifically an obligation for parties in a transboundary context to conduct an environmental impact assessment. And in the Antarctic Treaty Protocol on Environmental Protection, as well as in UNCLOS Article 206, we have similar specific obligations in treaty law. It was also mentioned in the nuclear test case, argued by New Zealand, but then not decided by the court. The first time the International Court of Justice actually dealt with impact assessment was in the pulp mills case, where the court specifically stated that the obligation to preserve and protect has to be interpreted in accordance with a practice which in recent years has gained so much acceptance among states that it might now be considered a requirement under general international law, i.e. Customary international law, to undertake an environmental impact assessment where the risks that the proposed industrial activity may have a significant adverse impact in the transboundary context, in particular on a shared resource, has to be conducted. The ICJ further considered that the EIA needs to be conducted prior to the implementation of the project. But the ICJ also said that the content and scope of EIAs, and that's where I think EU practice has had an influence, had not yet been defined either by general international law or by statute. Rather, the ICJ referred back to domestic law. So should determine the EIA's content in its domestic legislation. Other international tribunals have also dealt with impact assessment. So, for example, in Mox Plant, the UK breached its obligation under UNCLOS because it failed to carry out a proper environmental impact assessment, among other obligations. In the 2011 advisory opinion, the CBET chamber stressed that the obligation to conduct an environmental impact assessment is a general obligation under customary international law, highlighting that extend beyond the scope of the application of specific provisions of the underlying regulations, i.e. The customary law obligation is more extensive and means that maybe public consultations have to be held. And in the South China Sea arbitration, while the tribunal could not conclude whether China had actually carried out an environmental assessment, it said that in any way, in any case, China had violated the 206 UNCLOS obligation because it had not communicated the impact assessment reports. So that's the nature of our customary international law obligation as it historically stood. As you can see, a fairly recent development in customary international law And we marry this obligation with the conduct of EU sustainability assessment. In the EU, in accordance with Agenda 21 and the 1992 Rio Declaration, the EU established these SIAs to mainstream environmental and social concerns into policy with a view to promoting sustainable development. Since the 1990s, the Commission has developed processes implementing the precautionary principle with a goal to better understand the benefits and costs of policies. An SIA seeks to identify the potential social, economic, and environmental impacts using the 3 pillars of sustainable development. Today, the SIA is at the vanguard of a holistic impact assessment tool, showing evidence to be fully integrated instruments and including recommendations for enhancement and mitigation where necessary. The first model of an SIA was commissioned by the European Commission for the WTO Millennium Round assessment. So it stems from 1999 as a tool. What is interesting is that this tool that is deeply integrated into EU law has since spread to other international organizations. And here I will just briefly mention the World Bank. The World Bank has always, has for a long time, since 1989, required environmental assessments of proposed projects financed by the World Bank. And as you can see in development steps in 2013 and 2016, the World Bank has really expanded the scope of the environmental assessment, first to include human health and safety, and then also social aspects, resettlement, indigenous peoples, physical cultural resources. And now, in 2016, wholesomely replaced these policies, whereby now an environmental and social impact assessment has to be conducted that identifies the potential environmental and social impacts of a proposed project, evaluate alternatives, and designs appropriate mitigation management and monitoring measures. Now you can say another international organization has picked up the idea of sustainability impact assessment. That's fantastic, but that doesn't make it customary international law. But more and more, we see that this practice is then also picked up by the international community as a whole. For example, the Inter-American Court, in its advisory opinion on the right to a healthy environment, talked about holistic impact assessment being required that takes the social and economic aspects, especially the rights of indigenous peoples, into account. In the ICJ decision in Costa Rica versus Nicaragua, we have not just an obligation to conduct an impact assessment that had been violated and compensation had to be granted, but the court also took the economic and social aspects of that of the project into account, especially when compensating for environmental goods and services. Equally, we can see that human rights tribunals in Europe, the Americas, and Africa have requested that health and other human rights impacts, particularly rights of indigenous peoples, have to be taken into account in the conduct of a domestic environmental impact assessment, and even a transboundary one. And I would argue that there's now widespread international practice of SIAs and the impacts on the Sustainable Development Goals. So expanding the notion of an environmental impact assessment to include social and economic concerns. So what does this research conclude? I would say that the assessment of the sustainability impacts, not just mere environmental impacts, has grown to be part of customary international law, especially with regards to health and other human rights. The EU's trailing of the and trailblazing of the SIA methodology, first for trade and then for all EU legislation, has trailblazed the way for the SDGs to be integrated into impact assessments. While there's not a conclusive tribunal decision yet, the practice of other international organizations outside the EU context indicates a new interpretation of an existing customary international law, and you will forgive the Cambridge academic that more research is required. Thank you very much. I hope I'm more or less on time.
Thank you very much, Dr. Gehring. And you were perfectly on time with, I even think, 1 minute to spare. So I hope that goes towards the time for discussion afterwards. But for now, we move on to our second presentation by Dr. Papastavridis. Dr. Papastavridis is a postdoctoral researcher in international law of the sea at the Faculty of Law of Oxford University. He's also a part-time lecturer in public international law at the Democritus University of Thrace, a research fellow at the Academy of Athens, and a fellow of the Athens Public International Law Center of the University of Athens. Dr. Papastavridis, the floor is yours.
Thanks so much, Nina. Many thanks to the organizer for the very kind invitation, especially my dear old friend Panos. We shared in the morning about how EU is influential, and from Fernando, especially as a key player, a key actor, a driver for the development of customary international law. What I'm going to try to showcase in the next 15 minutes how this is applied in the context of the law of the sea. So I will be speaking on the issue of how EU uses as a legal framework rules of customary international law of the sea, specifically when it comes to law enforcement at sea and search and rescue at sea. And I will see how EU, first of all, interprets, these rules, and what kind of insights and what kind of takeaway points can we take from this. Now, as a matter of introduction and background, that the EU, you referred that UNCLOS is one of the EU is party to UNCLOS. That's true. It's been a party since 1998. The only regional international economic organization has been a party to UNCLOS. It is in 1998, according to the Annex, I think Annex 3 or 4 of UNCLOS, did make a formal statement on what kind of competencies EU has. And I'm speaking to people very well versed in EU law. They used, the major, the issues that the EU has competence, like fisheries, safety of shipping, prevention of pollution. These, issues that the EU enjoys exclusive or shared competence. They did refer to the possibility of amending this formal declaration, but this has not happened as of yet. Nevertheless, the EU is being, very increasingly, and it will be in the future active in other kind of fields of, international maritime law of the sea. We have put in a snapshot that we can, if we want later on, we can go into details in 3 CDSP, Common Defence and Security Policy operations. The EU operation Atalanta of Somalia, EU NAVFOR operation Sophia, that has now been, ceased to exist and has been replaced by UNAVFOR operation in Central Mediterranean Sea when it comes to trafficking of arms in Libya. And we have also Frontex, European Coast Guard, European Border and Coast Guard Agency, been active in the Mediterranean Sea, specifically Mediterranean Sea and Atlantic Ocean. And in addition, we have EFCA, the European Fisheries Control Agency, and the list goes on. So the point is that EU is operating in areas where the legal framework, the applicable rules when it comes to what kind of rules the EU will follow, is not is not similar, identical to those that actually EU has signed up by joining UNCLOS. Therefore, what's basic source of international law? Therefore, it goes without saying that the applicable legal framework must be, by definition, customary international law. So I mean, I could speak for. I will have only 50 minutes, so I cannot, address all the issues that, all the activities that EU is doing. I will try to focus mostly on search and rescue at sea, and specifically also on law enforcement at sea, and try to extrapolate certain conclusions, say how EU refers to these rules, alludes to these rules as the applicable legal framework. What kind of interpretation does EU give to these rules, and what kind of actually outcomes can we take when it comes to interpretation of customary international law, the tricky project actually, main goal. The outcome, conclusion, the basic conclusion is that indeed the EU in the majority of cases has been actually developing rather than affirming. It has affirmed the rules, but also has added it's contributed significantly, and it is contributing significantly to the development of customary international law. So first of all, let's start with Frontex. You have a very basic regulation, not EU, not Frontex regulation, but one regulation that has to do with how the maritime operation coordinated by Frontex. Typically, it is the member states that are doing those operations. However, Frontex has assumed a coordinating role, and also in the very more recent EU regulation, Frontex has also obtained more powers. Frontex, and this will be probably increased in the future, not only with Frontex but other EU agencies. So, in Recital 9 of the preamble of the regulation, it says that the regulation says that when coordinating border surveillance operation, the agency should fulfill its task in full compliance with relevant union law and relevant international law. And this also alludes to all the treaties that the EU is not party to, like the SOLAS Convention. I think it was referred. I don't think it was ever referred to SOLAS Convention, but other conventions that they are applicable, including of course the relevant rules of international law. So from the EU. From the outset, when it actually sets out its legal framework, it does refer to customary international law. Now, the first, case study, it is, and I apologize for the very long, it is mostly notes rather than PowerPoint, but it is, let's go and see something on the situation of distress. So just as a background, one of the main, when someone wants to discuss and contemplates on issues of search and rescue at sea, the key issue, and for practitioners and human rights activists, is when distress has been established, when there is a situation of distress calling for states or vessels in the vicinity to render assistance to people, right? So UNCLOS in Article 98 refers to the situation of distress as the trigger for an obligation and duty to render assistance at sea. Similarly, the International Convention on Search and Rescue, the SAR Convention, we refer to this henceforth, has three kind of situations, designates, and the one that triggers an obligation of due diligence, where is my friend here, due diligence, and best efforts obligation is the obligation when there is distress, which is defined as a serious risk of people that when positive information is received that a vessel or a person is in grave and imminent danger. And this is the only thing that the SAR Convention does say. Now, EU regulation, very interestingly, goes and defines, the situation of alert, awareness, uncertainty and distress, as per the SAR Convention. But then it has, 10 situations, conditions that will be taken into account to determine the existence of distress. So if you go through, I won't have time to just illustrative. If you go, through them, you see issues of, let's say, unseaworthiness of vessel, issues of, the availability of necessary supplies, such as fuel, water, and food to reach the shore, the presence of qualified crew and command of the vessel. And the question is how this has been infiltrated in the EU regulation. There's nowhere we can find this in another international instrument, so EU is a pioneer in this sense that actually adds this criteria for the determination of the customary concept, the notion of distress, which triggers the customary obligation of, search and rescue. And in my humble view, I think it's pretty sensible what the EU is saying, specifically against the background of what happens in real life time. And if you want to try to tease out what kind of tools, canons of interpretation we'll use, to me it seems that it is mostly like a purposive interpretation. So we use the purpose of the search and rescue is, of course, to save lives at sea, right? So you will interpret the idea of a serious and imminent threat to the risk of people by having in your mind the object and purpose, which is to save lives. So I think this is a very the way that EU interprets the relevant rules. I think it's based on the object and purpose of the specific framework, and also by the subsequent practice. So what EU member states as such or other states have experienced in real lifetime, right? So if you see this kind of vessel here, I've put in the picture, are they facing are they in need of immediate assistance? Apparently, yes, right? They are de facto an unseaworthy vessel, and which are de facto in a distress situation. Do we have to wait for a distress call? Again, my view is not, right. So I mean, the way that the EU in its regulation construes the concept of distress and the criteria, the indicia that has put the indicators that has actually included, I think it's towards a development of the relevant rules of international law. Now, a second related concept, where again EU seems as a driver for future development, it's the idea of place of safety. So, under general background, you have an obligation under the international law of the sea to rescue some persons that are in distress at sea or the boat, and the only obligation you have under the law of the sea, once you have rescued them, is to deliver them in a place of safety. That's what the Search and Rescue Convention stipulates. Now, IMO has, in a non-binding instrument in 2004, construed the concept of place of safety as follows: is a location where rescue operations are considered to terminate and where the survivor's safety or life is no longer threatened. Okay, and basic human needs can be met. Now, this has raised controversies in terms that if you look this through the exclusive lens of the law of the sea, that's very fine. But if you want to rescue this person and leave them and get them to Libya, there may be other kind of considerations coming into play, right? Not only law of the sea and international maritime law, but also human rights law. In the context of the International Maritime Organization, there have been efforts to amend the Search and Rescue Convention and to have a more progressive reading of this idea of place of safety, including having some human rights and also a duty of disembarkation in the state that is responsible for the search and rescue region. These efforts in the international global context has been to no avail. So no amendments have been established in the context of the International Maritime Organization. Nevertheless, EU regulation comes to add its own stone to the development by actually replicating the definition of place of safety in regulation, Regulation 656, which I said is the applicable legal framework for EU operations conducted by Frontex at sea. And it actually, replicates the definition, but adds something which are in italics, take into account the protection of their fundamental rights in compliance with the principle of non-refoulement, which is okay. It's pretty sensible, right? It's not, you don't, break grounds here, huge ground, but still, if you take into account the whole debate of states being and other actors being more reluctant to put more, obligation to the state that rescues this person or the vessel that rescues these persons, I think it's a very good and welcome development. So, I mean, it is an interpretation which is, in my view, it is taking a systemic degradation, or my good friend here, Article 31.3c of VCLT, taking into account other relevant rules of customary international law and also treaty law, which is human rights, and refugee law, specifically the principle of non-refoulement. So I think it's again, it is an interpretation by EU that is resting on general canons of VCLT, but actually trying to read this in a more evolutive manner and more systemically manner. Now, to close on the issue of EU operation and Frontex operation, here we don't have a development, a modification of the rules, but rather like an affirmation and confirmation of what is the lex lata. So the EU regulation has also many provisions on what you can do, what EU operations can do in the respective maritime zones, including the territorial sea, the contiguous zone on the high seas. Now, this is, in my view as a law of the sea practitioner and an expert, is very much in accordance with international law of the sea. For example, it is Article EU Regulation 656, Article 6 and 8, sets out that when you intercept a vessel that they have, you are actually reaching a specific, going without you're suspected of smuggling of migrant, and it's going to the shore. You can have a power either to seize or, I will try to finish, either to seize or divert the vessel, which is something which is in line with normal rules of international law. And also one of my favorite topics, and it's very because it's very controversial, is the issue of stateless vessels, which is something which nobody knows what's happening with the stateless vessel, and EU doesn't know as well. So it says that it depends on the relevant rules of domestic law. So nothing to add there. I have only 30 seconds, just going to the last case study, and then I will conclude with your permission. Operation Atalanta, handover of pirates. I didn't take this photo. I could be, because I'm working on piracy, and I could be the one, but I'm not. And I'm claiming, that I have taken this picture. Now, you know that the EU has been, working on the coast of Somalia based on council decisions, and still is there. EU Operation Atalanta is still there. Now, it has been debated, long debated, whether under international law of the sea and customary international law, when a state arrests a pirate, whether this particular state has competence jurisdiction to try this specific pirate. This is in line with Article 105 of UNCLOS as per customary international law. Now, EU has a different view, and this is based also on states' practice, right? Because what states have been doing in the context of Somalia and also of the coast of Gulf of Guinea, where I also have been consulting UN Office on Drugs and Crime, is to do handover agreements. I don't want to, Greece never wanted to have any pirate to try any pirate, so what Greece and other European Union states did is to transfer to the willing state, which is Kenya, Seychelles, Mauritius, upon a very good transfer of money, of course, to those states, right? So this is, I think this is another, incident of development of international law based on various maybe interpretive tools, like again the optional purpose to actually have people punished for their crime, the hostis humanis generis of the world, a principle of effectiveness, so effective interpretation, and also based on subsequent agreements and practice by states. Again, Article 31.3 comes into play. And to conclude, just a snapshot is the EU is being actually, as I said, very increasingly involved in the maritime domain, and I think we can take this practice of EU and use it as a means of practice, as Panos was referring in the beginning, as a means of practice of interpretation, and try to get some conclusions and outcomes when it comes to the rules of interpretation of customary international law. Thank you, and sorry for taking more time than it was accorded to me. Thanks.
Thank you very much, Dr. Papastavridis. I'm a lucky chair because I have a complementary panel, so the 1 minute saved in the first presentation was 1 minute used here.
Thank you, Marks. Thanks, Marks, for giving 1 minute.
Thank you very much, Dr. Vatsov. I think that you and I will need to have a conversation during the dinner, because this talk about exceptions is very interesting. It's a big part of my research, so I appreciated that point. Thank you. Now I would like to open the floor to our audience, both in person and online, for any questions that you might have. The microphone is with our colleague, Marina Fortuna. And for the audience online, please indicate in the chat or with a raise hand option if you have a question, and then you can tune in or we can read out your question.
Hi, I have a question for Markus. I'm Eva Casoldi, I don't know if you can see me. Thank you very much for your presentation. It just came to mind that there is a case in the Ombudsman about the EU-Vietnam Free Trade Agreement. And there the Ombudsman said that conducting a human rights impact assessment is in line with Article 3 and the obligation to respect international law, but it's not a legal obligation. And that it would be in line also with the principle of good administration. So I wonder whether this would change your argumentation a bit about the existence of a customary international law obligation.
I have a question for the Law of the Sea crowd. I would be very interested in your position on the role of search and rescue operations as contributors to customary international law, because essentially, maybe for both of your presentations, there are private actors who have initiated legislation. Maybe on the one hand, the search and rescue operations, which are mainly carried out by non-governmental organizations, and then IUU fishing, which is of course the small brother, but unsustainable fishing seems to be maybe the same context of private actors being the one responsible for the ensuing legislation. So maybe what's the role of those in the development of customary international law?
Thank you very much. I enjoyed all three papers very much. Very different ones, and I have a question that is a bit more theoretical, but that came up while listening to the three of you, and that is actually a question of customary international law, so perhaps it's a question to Panos, but let's see how far we can go. I mean, if the European Union gives a certain interpretation of customary international law, the question then would be, to what extent would that interpretation also be binding for its own member states? I was listening to the sustainability impact assessment, but also to the other UNCLOS situations that you were describing. Keeping in mind also, for instance, that if treaties are concluded by the European Union, they're also binding on the member states, right? So what about interpretations of international law? And I'm not really sure if this is a customary international law question or a European law question, but let's see.
And my question is, I think, addressed to the three panelists one way or another. What I thought this panel has shown very nicely and clearly is why the practice of international organizations have to count for the creation and interpretation of custom, why it would be ludicrous, as the US or Israel or some participants in the ILC debates have argued, to say that no, it's only states, quasi-states that contribute to custom. And of course we get a bit of a something we knew already, but that is very nice to see elaborated upon, the fact that the EU is a laboratory of some description for the creation of practices and rules that become very influential over time, and it is a powerhouse in that connection, 100%. But my question is, we know as well that the EU can serve as an exporter of norms in a very deliberate way. People like Anu Bradford and others have been talking about how sometimes there is a clear strategy for the EU to import norms, especially through treaty making, like make EU law part of everything. In the practices you guys have described today, can you discern any strategy on the part of the EU to promote or change or develop customary international law, or is this just one of the situations in which EU stuff ends up mattering just for this, for the simple fact that it is practice? I would be curious to see what your views on the agency of the EU in those processes and the strategy of the EU are.
Hi, my name is Jed. To touch upon the law of the sea questions, and also to maybe bring it back to the this morning's panel, as well on the court, I had a kind of hypothesis that I mentioned somewhere where I found the Sea Watch case and some of the cases dealing with law of the sea by the court. It was more confident with engaging. That was the one that bucked the trend. There was more engagement, serious engagement, the law of the sea arguments, maritime law. And maybe just to ask what you think about that idea that maybe that confidence comes from the fact that the EU is also, on the other side, a contributor to the law of the sea in other areas, whether that makes sense or not, basically, what your thoughts are on that. Thanks.
So apparently there are a lot of more questions here, so I hope you're taking good notes. So Ramses beat me to the punch because that was pretty similar to what I was about to ask. As a common thread to all your wonderful presentations is essentially what is the reaction or the discussion going on after those interpretations by the EU, and if in those discussions there is also kind of elaboration on whether this is a good idea, this is the object and purpose of the rule, that kind of thing. So essentially whether the interpretations of the EU are persuasive in of themselves. One extra thing which Nina also touched upon with respect to the presentation of Dr. Vatsov, and I was expecting Dr. De Hoog to jump at that, but apparently he's waiting for his time. About the exception, because you mentioned that the EU is kind of, in its interpretation, is carving out either a new exception which seems to go kind of contra legem, or at least the written legem. And there my question would be, is in your view, is that still in the realm of interpretation, or they are actually trying to modify the rule, trying to completely change it? Or in view, it's one and the same thing? So that would be one clarification.
So before we go back to our panel, are there any questions online? Okay, in that case, I suggest that, because it seems that most of the questions were addressed to all three panelists, that we do it like in the previous panel, and we simply go through all three panelists to address these questions. So then, Dr. Gehring, the floor is yours.
Yes, thank you very much. Fantastic questions. And again, I'm sorry not to be in the room. Yeah, I think it was kind of revolutionary that the Ombudsman in the first place concluded that a human rights assessment was necessary, right? So I haven't specifically looked at human rights assessments as such. I've more looked at the expansion of the existing customary norm on environmental impact assessment. But under those conditions, I can kind of see why, because it wasn't really an established practice of the Commission, why the Commission refused to comply with the Ombudsman's recommendation in that case. But in my argument was to see the concept of sustainable development as consisting of three pillars: economic, environmental, and social, and that the concept of environmental impact assessment is slowly, through the practice of the European Union, be expanded into other areas such as social and economic aspects. But it's a really important point, and I think it needs to be integrated into the paper. So I'm really grateful for that. Yeah, I mean, I loved, I think the question by Ramses about are the member states bound by the interpretation of international law that is put forward by the European Union. I think all actors of international law, all participants in the international system, to a certain extent, are bound by the shape of customary international law. So I don't agree with the sense that custom or treaties by international organizations are a completely different field of international law and follow completely different rules. Of course, there are modifications, when you're dealing within IO, but the general contribution is binding also on states. And I know that's controversial, but I think it speaks to it's sort of the general public international lawyers would probably agree. I loved Fernando's question about the EU as a powerhouse. I've detected a bit of a strategy especially when it comes to trade agreements, right? So the obligation to conduct your own SIA has been included in EU trade agreements for a long time, and therefore has spread around the world to where the content of these assessments is left to the trading partner country. But most recently in the TCA, the EU-UK trade agreement, we've seen specific content standards of what needs to be included in environmental assessments and a bottom line, right? So you can see how the EU is, through contract, through treaty law, trying to ensure that its interpretation of what is perhaps a minimum standard on impact assessment should be adhered to. I found that interesting. I'm not sure I can really speak to Jet's question, but I think Panos asked the last question on the sort of pushing the envelope on interpretations that then actually modify the rule. I think to a certain extent, all actors in international law are trying to do that when it comes to custom. In my view, because custom is so general, it's really quite difficult to discover the edges of that strategy and the precise point where the EU practice has really replaced the common interpretation of the norm of customary international law. But yeah, those were my thoughts on these stimulating questions. Thank you.
Thank you very much. And now the floor is to Dr. Papastavridis.
Thanks so much. It's good to be second, so we have time to ponder your answers. Thanks for all the very thoughtful questions. I mean, I will try to address them shortly. Don't show me them 1 minute, right? So I have. So the first one was on the private actors, right? So how. Whether this is how this influences the conformation of customary international law. I think it goes the other way around. I think that they are. What is really interesting is the way that states are responding to these NGOs' actions. For example. When you close your ports to a vessel that has rescued someone, and because you're like Italy did, and it didn't accept this, people that have rescued persons going to their ports is how this is, does play with Article, let's say 98 of UNCLOS, with General International Law of what distress means, right? All this memorandum of understanding that this, states have established with private actors. Where they exclude them or not exclude them from search and rescue operation off the coast of Libya. So I think it is interesting is how NGOs are, as private actors, trigger reaction of states, and how you can read this state practice in the formation of international law. And I think it's interesting, especially when it comes to what are the duties and obligations of coastal states as the responsible search and rescue coordinators and private seafarers that they are actually rescuing persons. Now moving to the related question on effective and close your own research. It is EU can be found, I think, responsible, usually not for directly actually authorizing, let's say, a pushback, operation. However, firstly, when it has draft the operational plan of the agreement, right, or of the operation. For example, under the EU regulations I referred to, the one who actually makes the whole operational plan is the EU, is the director of Frontex, right? So it's like how much it's like co-authorship of an instrument, which is, it's organic link with the European Union under Article 6 of ARIO, that will actually found responsible if I say Turkey is a safe country, which is not for, let's say, Kurds maybe. So this means that, ostensibly this will, I think, engage direct responsibility of EU and attribution of this conduct to EU and then responsibility. And also when there is this international coordination center of Frontex, where all together somehow have knowledge, awareness of what is going on, right? So this is maybe, we can have again another issue of co-authorship. Otherwise, you have to revert to the indirect responsibility, derivative responsibility of EU under the respective articles of ARIO. But thanks for very, very, very good questions. Now, on the question of bindingness, Rams asks, this is interesting. I think they are, and this is linked also to Panos' question. I will address simultaneously. So yes, I agree with Markus. It's not like it's not a direct obligation to follow in terms of custom international law, not in terms of EU law, but in terms of custom international law, what EU does. However, I think, it is, generally speaking, the way that EU has interpreted, let's say, in my kind of area of research, the idea of place of safety or what is distress. So when next time there will be like an IMO, a discussion within the IMO, when with respect to this concept, I don't think Greece or Malta or whatever states it will be not very easy for them to differ from what the EU as a key actor has taken up as their view, right? And how this has been taken up by this interpretation. I think there has been, for example, when it comes to handover agreements that I referred to, interestingly, ECOWAS, another regional organization in West Africa, has taken up the same stance, right? So they have said, okay, what the EU did in East Africa, it's great. Let's do it also in Gulf of Guinea when we have piracy incidents, right? And again, I think this is, and going to Fernando's question, I think this was lamentable the way that states approach the practice of international organization. I think specifically when it comes to EU representing 27 member states in a vast, area of practice, I think this should have been seriously taken into account. And as I repeat that there must be, I think they will be influential in the future how, not only law of the sea as identifying the rules of the sea, but mainly, interpreting them, because law of the sea it's an area which has been, well-established custom in international law, but it needs some, sometimes evolutive interpretation. And this is EU is doing this very rightly. And to the question of the Sea Watch, yes, I read the Sea Watch. I was also offered a comment on the Odysseus block on this one. It was an excellent law of the sea case. For example, reading the Sea Watch, also the Advocate General view, it was in line with the international law of the sea. I think it was EU being a party to UNCLOS, I agree, and having this on also states being part to this kind of arrangements like, the SAR Convention, IMO instruments, was, EU was very comfortable in laying its interpretation in custom international, in law of the sea. However, again, as you rightly said, did not offer many insights. It just taken them as granted the rules, especially when it comes to the obligation of the receiving state, the port state. That's all from my side.
Thank you very much. And I think we tend to agree with you. It requires many more words. But this was wonderful. So just very quickly to thank our panel with a round of applause. Thank you very much also to the audience for your wonderful questions, which I think inspired very interesting debates, and hopefully will also transcend the panel today. For now, we take a very short break before we move to our next and final panel. Thank you all.